High Court has interpreted the legislative competences or powers of the federal parliament just like your Supreme Court has. Our Constitution gives the federal parliament a list of powers just like your Article 1 does. But it's a longer list in Australia. And I think it would be fair to say that, although this is a complex matter, the Australian High Court, even though it's taken a very broad view over the course of time of the scope of the powers of the federal parliament, I don't think it's taken quite as wide a view in its interpretive methodology as the US Supreme Court has. Although this is a complex matter, the illustration I would give is our Commerce Clause. So like you, we have a Commerce Clause which gives the Commonwealth Parliament power to legislate with respect to interstate trade and commerce, as well as in commerce and trade and commerce with other countries. But unlike the US Supreme Court, the High Court of Australia has placed a lot of emphasis on that notion that the commerce must be interstate, and has held back from the view that it's possible to regulate matters that have a kind of secondary influence on interstate trade, even if the regulation is focused on something that's the trade in some goods or services that are within a state rather than across state borders. Now, I don't know whether I'm presupposing too much knowledge here about your Commerce Clause jurisprudence, but surely you have had some introduction to that, or not? I'm not sure. I see the odd blank look, but so I don't know how much to presuppose or not. But nonetheless, even though the Australian High Court hasn't read the Commerce Clause so widely, it has, under other heads of power, read federal power very broadly indeed. And so the one head of power, it seems to me now, that is going to do a lot of the work that the Commerce Clause has done in the United States is the Australian corporations power. The Commonwealth in Australia has power to legislate with respect to trading corporations and financial corporations and foreign corporations. And only a couple of years ago, the High Court brought down what for me is a very controversial decision, in which it held that the Parliament could regulate entirely employment relationships between employers and employees, provided that the employer was a trading corporation or a financial corporation. And so a law not simply directed at trading corporations in terms of, for example, their trading activities, but a law dealing with their relations with their employees. Controversial because there's another head of power in the Australian Constitution, which gives the Commonwealth power to legislate with respect to employment relationships, but in very narrow terms. And I won't go into the detail about that, but that very narrow provision of power there, in some minds, implies that the corporation's power should be read so as not to swamp that other head of power. But that's a controversial thing, and I don't know how much constitutional law you folk have studied, but there are always these questions about how do you read a whole list of heads of power, and do the terms of one head of power imply limits on another. But to actually reason that way is to adopt what is called reserved powers reasoning, which the courts have tended to repudiate in Australia and the United States. Now, for some of you who've studied that area, I hope that you appreciate the point that I'm making there, but I appreciate also that it does presuppose some understanding, and I don't really have time to say much more in detail about that. Because what I want to concentrate is on rights. And here what is very interesting is that even though the Australian Constitution doesn't contain a Bill of Rights and has no explicit guarantee of free speech, the High Court of Australia has discovered an implied freedom of what is called political communication or political speech. Not a guarantee of free speech generally on any topic, but speech about political matters, about the performance of elected members of the legislature and of the executive government. How did the High Court of Australia discover this implied right to political communication? it did so by reflecting on a few things. The first thing is that the Australian Constitution, in language very similar to the American, provides that the Australian Parliament consists of members directly chosen by the people. So that the Australian House of Representatives and the Australian Senate, which are very similar to your House and Senate, are chosen by the people. And the High Court, to generalise, drew the inference that the framers of the Constitution had designed a system in which representative democracy would occur. And the court inferred from this notion of representative democracy the idea that you can't have an effective, well-running democracy without free speech in relation to political matters or governmental matters. In doing so, it drew not on so much American decisions, but several Canadian decisions, which had drawn similar inferences from the democratic features of the Canadian Constitution. And these Canadian cases were decided before the Charter of Rights and Freedoms was introduced in Canada. And so the court inferred the existence of an implied freedom of political communication, which was an extraordinary step for it to take, because the framers of the Australian Constitution had deliberately taken the religion clauses from the First Amendment, but had just as deliberately not taken the free speech clauses and put them into the Constitution. And so it was controversial because the court was finding an implication that seemed to go against what the framers had intended to create. Controversial also because it was an unelected court that would confer upon itself by this inference the power to scrutinise federal laws to see whether they interfere with free speech or not. Now, to perhaps American ears, that doesn't seem so strange at all, because you're accustomed to the notion of free speech being a right, and accustomed to the idea that the US Supreme Court will scrutinise state or federal legislation to see whether it unduly interferes with free speech and strike down laws frequently on that basis. But it was controversial in Australia because there was never that deliberate decision to include free speech in our Constitution. And more probably importantly, it's not just the notion that free speech is implied by the Constitution, it's the balancing judgments that the court has to make when assessing legislation to see whether it unduly interferes with free speech or not. And critics of this line of reasoning say that in substance what this means is that whenever a parliament enacts a law which interferes with free speech, debate within parliament, debate within the parties and between the parties involves the question, does this law reflect the right balance? Does it unduly interfere with free speech, or does it appropriately address some social problem or not? And for the courts to take for themselves the power to ask that question again and second-guess the Parliament and override its decision is controversial because the court isn't democratically elected. And it's assessing a finely tuned, finely adjusted issue upon which opinions can differ. And the key case in which all of this arose illustrates this. And this case is called Australian Capital Television versus the Commonwealth, which was decided in 1992. I'm talking about a case that was decided almost 2 decades ago, which makes me think it's time for a 20-year reappraisal. And this case involved a federal law which I think you might find a little bit topical, because it was concerned with the problem of corruption of the political system by political donations being made to political parties and members of Parliament. In fact, the government commissioned a report into this issue, and the name of the report was this: "Who pays the piper calls the tune."